Very last panel, and I was heartened by Mark's comments that with the exclusivity provisions provided for biosimilars, patents are not necessary anymore, potentially. So I think that we'll have a lively discussion here, and I just wanted to announce that Vicki Brewster, who was originally supposed to be on this panel, had a family emergency, so she won't be joining. That means that for some of the questions that we were intending to direct her way, I will be the questioner and the respondent. So that's by way of explanation. We thought we'd start by having Professor Eisenberg give a general background on what is available as alternatives to patent protection, and then we'll all be on the same page. And then we'll talk about trade secrets for a bit, and then we'll talk about regulatory exclusivities.
Okay, very good. Thank you very much, Michelle. One of the great pleasures of aging as an academic is I get to sit on a panel like this surrounded by my incredibly distinguished former students. So I'm going to try to do a quick flyover of non-patent sources of legal protection for biopharmaceutical innovations, leaving lots of time for my co-panelists and for Q&A and discussion. I understand that this is a pretty knowledgeable group, so I'm just going to hit the highlights here, and also it's somewhat redundant to things that others have covered earlier in the day. The biopharmaceutical industry, of course, includes many ardent champions of a strong patent system, and yet the patent system is in many ways a poor fit for biopharmaceutical innovation for a number of reasons, not just the very recent problems with patentable subject matter that we heard about earlier in the day, which excludes certain areas of innovation, such as diagnostics and IT-based products, perhaps methods of treatment. But there are other problems as well. Timing is a huge problem. The most valuable patents on biopharmaceutical products are product patents on the active ingredient that are filed early in the course of product development, but early filing means early expiration, so the patent term begins and ends too early relative to product launch. Other patents may follow, but they are often narrower in scope and they face more prior art, so their validity is more uncertain. And so these limitations have caused innovating firms to search for other sources of protection against competitors. One time-honored source of protection is trade secrets. Until recently has been primarily state trade secret law, but federal trade secrets legislation, as we've been hearing throughout the day, has passed both houses of Congress and is likely to provide nationwide protection that looks a lot like the Uniform Trade Secrets Act, and we'll hear more about this later. Trade secrecy is valuable in this space, but it only protects information that is not publicly available. That still leaves room for it to do real work in some areas of biopharmaceutical innovation, including protecting disclosures in the context of relationships with employees or with research collaborators, protection for regulatory data that are necessary to get FDA approval for a product but are not publicly disclosed, manufacturing methods, which, as we were hearing about this morning, are likely to be very important for biosimilars. Generally, trade secret law has operated alongside patents on products rather than as an alternative source of protection where patents fail. But sometimes trade secrecy looks more like an alternative. For example, Myriad Genetics, I understand, has a large database of mutations in breast cancer genes that are not publicly disclosed, that presumably give it a competitive advantage quite apart from their patent rights, which have taken a hit. Trademarks and trade dress may also confer a valuable advantage in the biopharmaceutical marketplace, particularly when patients and caregivers worry that there may be differences between products, between branded products and imitations that turn out to matter. This is particularly important in the OTC market, where generic substitution is not automatic and where consumers may be more likely to go for the familiar brand. It may also be important for biologics. And so this could be an important emerging form of protection. So these are the older, more standard forms of non-patent protection that are not specific to the biopharmaceutical industry, but that may be useful in the biopharmaceutical industry. In addition, we have a growing number of federal statutory provisions, summarized briefly in the right-hand column on this slide, that confer protection against competitive entry in the market through the timing of FDA approval of competing products. These provisions are less an alternative to patents than they are sort of nested in a number of legal regimes, including the patent system, trade secrets, state generic substitution laws. And they were designed around these other legal regimes rather than as a substitute form of protection. The vocabulary is not entirely consistent. I am using here the term regulatory exclusivity to refer to all of these various legal provisions that work by deferring regulatory approval of a competing product. Some people would distinguish between market exclusivity, such as the 7 years provided by the Orphan Drug Act, which bars FDA from approving during those 7 years another application for the same product for the same indication, even if the other applicant submits its own NDA with its own full reports from its own clinical trials, versus data exclusivity, such as the Hatch-Waxman Act provisions that operate by deferring the time when you can bring a product to market under an abbreviated new drug application, or ANDA, do not prevent other innovators from submitting their own complete new drug applications using their own full reports of data from their own clinical trials. But these, when the cost of collecting and data and submitting a full NDA is prohibitive for generic producers, the effect it might be quite similar, which is why we saw very few generic products approved prior to the introduction of ANDAs in the Hatch-Waxman Act in 1984. Data exclusivity works alongside trade secrecy for regulatory data to defer competitive entry, but only for specified periods of time. In the case of the Hatch-Waxman Act, these periods are 5 years generally, with some qualifications, for a new chemical entity. At least if there's no patents, it's 5 years. And 3 years for a supplemental NDA for a product change or a new indication that requires further clinical trials for approval. Another provision of the Hatch-Waxman Act stays regulatory approval for an additional 30 months pending patent infringement litigation. So in effect, that extends the 5-year period to as much as 7.5 years in cases where there is a challenge to the patent. If there is no challenge to the patent, then regulatory exclusivity extends until the end of the patent term. That is, if there is a patent in the Orange Book and if the generic applicant is not including a challenge to that patent, the ANDA may not be approved until the end of that patent term. So the duration of regulatory exclusivity is very much intertwined with the patent system. In effect, these periods of time limit the commercial advantage conferred by data secrecy. After these periods expire, competitors may bring their products to market with an ANDA without having to duplicate the clinical trials to show safety and efficacy from scratch, subject to remedies for patent infringement. The Hatch-Waxman Act also facilitates generic entry by working alongside state generic substitution laws, which mandate pharmacists to substitute cheaper generic products that FDA has rated as therapeutically equivalent to a prescribed product unless the doctor insists on the branded product. But the Hatch-Waxman Act only applies to drugs approved under the Food, Drug, and Cosmetic Act, which is also true of most of the generic substitution laws. So we are in a different situation with respect to the biosimilars. It took further legislation to provide a streamlined, oops, I forgot to show this when it would have been relevant. It took further legislation to provide a streamlined approval pathway for follow-on biologics in the Biologics Price Competition and Innovation Act, which we were here
hearing about earlier, just to hit the highlights. Notable differences between the Hatch-Waxman Act and the Biologics Act is that there's much less of a regulatory break for an abbreviated biologics license application than for an ANDA. It's not so clearly better to file an ABLA than it is to file a full biologics license application without having to worry about regulatory exclusivity periods. There's a much longer period of regulatory exclusivity before an ABLA is approvable, 12 years. And moreover, these periods of exclusivity don't turn on patents at all. They don't vary with patents. It doesn't matter whether there's a patent challenge. Although it does include these funky provisions for exchanging patent information that the Federal Circuit has concluded are optional. Congress has also passed a couple of additional regulatory exclusivity provisions that work with both of these regimes, although in a slightly different way, basically by adding more time to whatever exclusivity you have under another regulatory regime. So you get 6 months of additional exclusivity for testing a drug in pediatric patients pursuant to a request from FDA, and you get 5 years of additional exclusivity for approval of a qualified infectious disease product, such as a new antibiotic to use against resistant pathogens. And because of the way these sources of exclusivity work, by extending the dates that defer a generic entry under other laws, they are cumulative. So you could potentially get 17 and a half years of regulatory exclusivity for introducing and then testing in kids a new biologic for treating serious or life-threatening infections. And that's getting pretty close to a full patent term, but it's a more valuable one because of the timing, at least compared to many product patents, because it begins with product approval, so all of those years are good years. That is, they are years that are not ticking away on the meter before your product gets to market. Moreover, you don't need to litigate to get the benefits of regulatory exclusivity, unlike the Hatch-Waxman Act provisions beyond 5 years. So FDA takes care of enforcement by keeping competitors off the market by declining to approve their applications. So regulatory exclusivity offers more certain protection, here we go, for a period of time without having to resort to litigation and persuade a court to rule in your favor. Was that under 10 minutes?
No, that was good.
Okay,
You're right on. So the regulatory exclusivities are a huge topic, and we'll address them a little bit later. I thought we'd focus on the trade secrets question, and I know you had some views about the value of trade secrets. You want to share those while I tee up the presentation?
Sure. So trade secrecy is sort of disfavored among academics because of its net effects on innovation are ambiguous. That we might be better off with more open disclosure so that others can, first of all, more eyeballs can check out the data and see if they say what people are presenting them as meaning. That's better for public health purposes, better as a safeguard against FDA acting, misinterpreting the data. And also it's better typically to allow more people to aggregate data from multiple sources and use that in making new discoveries. Some people think that the reason why California is a great place for innovation is because it has had relatively weak trade secret law in the form of provisions of the Business and Professions Code that are trying to protect employees' mobility. And so, there's some concern if you have federal trade secrets legislation, or if you have more robust trade secrets protection, or more reliance on trade secrets protection, that some of these state-specific limitations that have been very beneficial in certain regions will be preempted. Not on the, I understand that this is a cumulative, this is an additional remedy available to plaintiffs, but there may be some defense side limitations that might get preempted, and if so, there's some risk maybe that we'll see less innovation rather than more in the future.
So before Jay introduces the new legislation to us, I just wanted to give Deborah a chance as a practitioner representing clients to give a counterpoint to that view on trade secrets.
Yeah, I mean, I guess I would say not just limited to trade secrets, but all of these alternative forms of protection that, at least from the practice point of view, they're always, the pendulum swings in how robust our patent system is and how effective enforcement is both in the US and abroad. And I think for a whole host of reasons that are probably would take a whole nother panel to talk about, public sentiment has really swung against a patent enforcement regime driven in large measure by what are viewed as spurious business method patents and some of the high-tech patents that aren't necessarily needed to compete in that space. And the life sciences sector has been the unintended victim, I think, of a lot of that backlash. Everything from the AIA and post-grant challenges without needing to have standing per se to attack a patent, the fact that an injunction does not issue as a matter of right anymore but must be proven, post-eBay, and as you heard just an hour ago, the challenges in getting some pretty fundamental patents issued given the current case law on patentable subject matter. So for all of those reasons, the patent enforcement regime in the US is a much less hospitable environment than it was, let's say, 15, 20 years ago. And as a life sciences innovator, the hurdles to enforcing your patent successfully have increased. And so when firms look at making major investments in the development of therapeutics, they have to take into account what is the likelihood that they'll be able to recoup on that investment. And while there's math you can do on the patent side of the fence with such uncertainty around patent enforcement, it helps give certainty to companies when they're able to rely, particularly I think on the regulatory exclusivities, but also on being able to, if they can't obtain patents in certain areas, being able to keep those things as trade secret. And as I think Becky mentioned and maybe Michelle mentioned as well, of course, they need to be things you can keep secret. It can't be the product that you're introducing into the stream of commerce, but perhaps your manufacturing process and perhaps, if you've got genetic markers or the like.
Let me stop you there
Yes.
because that's kind of going a little bit further into
sorry.
the discussion at this point that we wanted to get. It is interesting to have the pendulum swinging in one direction for patents and in the other direction for trade secrets. And Jay was going to talk a little about the new legislation.
Okay, great. So then thank you very much to each of you for sticking around for the last panel. And I'm also, again, it's a really great honor to be on a panel with my former instructor, Becky Eisenberg, who really got me into this field and has kept me excited about it for a long time. So thank you so much, Becky. So trademark, patent, pendulum. Obviously, there's some legal developments that have made trade secrets a little more attractive, too. Obviously, we have a First Inventor Defense Act that created a first commercial user defense, so-called prior user rights. That obviously gives you some edge versus patents. It used to be that you could become an infringer if you kept something as a trade secret and that your invention was independently invented by another. Now you're prevented from that. That's no longer the case. We're still thinking about the Helson case. Is metallizing engineering still good law? Are you allowed to keep something as a trade secret for many years and just file a patent application whenever you wish and not be prejudiced by that prior trade secret? So obviously that result waits for us. But another thing that's made trade secrets arguably more attractive, well, I think just a little bit more so, though I welcome other views, is the new federal legislation, the Defend Trade Secrets Act. It awaits signature by the president, but it will be signed and this will become law fairly soon. In 2013, the White House put out a report recommending that trade secret law be federalized. As you know, currently in the United States, trade secret remains part of state law. And so as a result, they are enforced in state courts normally, although of course you have diversity jurisdiction, you have supplemental jurisdiction, but original jurisdiction resides in the state courts. So that created some difficulties. Obviously, some state courts are not as highly regarded as the federal courts. That also created difficulties with our trading partners who asked, well, we have a TRIPS agreement and we have this obligation to protect trade secrets. How exactly are you doing it? Well, we have this patchwork of different states. Some said this state trade secret law was not well harmonized. 47 out of the 50 states plus DC enacted the Uniform Trade Secrets Act, but often with variations. The statute is also not holistic. There are a lot of gaps in it, and courts have responded in different ways. So there are different sort of trade secret laws in different states. The Defend Trade Secrets Act creates original jurisdiction for a new federal cause of action for trade secret misappropriation. Again, it's original jurisdiction in the federal courts. It does not preempt or displace state law. So you have all the state courts, but you also have now this new federal system on top of it. Now, there's been a lot of this. If you've been reading blogs, you've probably heard about earlier complaints. A bunch of professors signed a letter complaining about the legislation. Many of the concerns that were identified in that letter have been changed by amendments to the Defend Trade Secrets Act. So there's been a lot of last-minute changes to the legislation. And it passed with pretty much overwhelming support. One of the big innovations of it, again, it pretty much just tracks the Uniform Trade Secret Act. So that's why I don't think this is such a momentous event in the history of intellectual property law. But one thing it does allow is an ex parte seizure proceeding. It's modeled after the Trademark Counterfeiting Act of 1984. So if you're familiar with that law and have worked on seizure proceedings through marks, it's the same kind of thing here. You have to make a showing of extraordinary circumstances, of irreparable harm, and you would file this order. You're also not supposed to publicize the fact that the seizure proceeding is going on. One thing to note that was the subject of much topic or discussion, especially here, I think, in California, has to do with the so-called inevitable disclosure doctrine. The inevitable disclosure doctrine stated that when a former employee left you and went to a rival, that through the course of her ordinary activities, she would inevitably disclose her trade secrets in some situations. The federal legislation gets rid of that or rejects the inevitable disclosure doctrine at the federal level. It also, again, it just sort of prevents an award of an injunction against someone taking a new job. And just, there has to be something specific, not just this more vague notion of inevitable disclosure. Again, with no preemption and a new statute with some uncertain boundaries, it's going to be, I think, a good time for lawyers to sort of figure out what the new federal trade secret law is going to be. And you have another venue, and you have more options. You have many states, and you also have the federal courts to pursue federal trade secret causes of action. Thank you.
So, Deborah, is it a binary decision whether to apply for trade secrets, or whether to keep your innovation as a trade secret or to apply for a patent on it? And how would you advise your client as to making that determination?
Right. So it's often, so it can be binary, but often it is both a complement to your patent protection or it's along the path to patent protection. So especially in the biotech industry, much of the time, at least part of what you're keeping as trade secret, you're hoping will mature into an invention that you can file a patent on, but it's still in its nascent stages. And how much of your trade secret or confidential information you end up putting in your patent filing may depend on what you need in order to support the disclosure itself. And, you know, so there are, I would say there are different ways of, that your confidential information can end up in your patent filing. It could also be that you make an election, for example, on manufacturing processes that folks were talking about earlier. It's not uncommon that companies would decide to file patents on their manufacturing processes that are innovative. And there you do make an election. It is a binary decision. You either file for a patent or you keep it trade secret. But even in the instance where you decide to file for a patent, until that patent is published, it can still be maintained as trade secret. And oftentimes, a lot of the foundational research and development that will lead to a patentable invention, the platform technology may be something that you wish to keep as trade secret because, well, this gets into a whole other topic, but basically because of considerations of for how long will this information be valuable. And either if the information has a short lifespan or essentially an infinite lifespan, if it's a platform technology that isn't necessarily disclosed as part of a patent filing, a company may decide not to disclose it. Or if the patents are not going to be granted on some of, for example, the gene sequence patents, now we can't get patents out in those areas, knowing that companies may be more likely to keep markers as proprietary information rather than trying to go for a patent on it and having the world learn their competitive advantage and not get a patent at the end of the day. So I would say it's both. It can be binary, where companies make an election, but it can also be just a natural evolution of research and development efforts into fruition.
So in practice, how do you see trade secret claims arising in the biotech sector?
Right. Well, I don't see a difference over time, but what I do see in the biotech sector, well, let me back up. I'd say in the biotech sector, one thing that's a little bit more unique, I think, than in high tech is that so much of basic research and development is done outside of big pharma or big biotech. So both with the passage of the Bayh-Dole Act more than 2 decades ago, and even now with the economics of basic research and development, a lot of innovation is happening in smaller firms or is happening at the university. And larger companies become involved either through sponsored research agreements, collaboration agreements, and the like. Even if these companies have internal research and development programs going on, they'll often have multiple projects targeting the same therapeutic disease state, for example. And they'll see which one looks like it's going to come to fruition or be most effective. Because of all of the collaboration work that takes place in the life sciences, my experience is that there is a higher proportion of trade secret misappropriation claims in the external business relationship contexts as a proportion of trade secret misappropriation claims than simply employee mobility. And so just to put some numbers around it, I think Symantec had done a survey maybe a decade ago where they found 3 principal ways trade secrets move. Number 1, far and away, is employee mobility. Number 2, external business relationships. And number 3 is actual corporate espionage. What I would say is in the life sciences sector, I think that number 2 bucket is more prevalent because of the nature of innovation. And for that reason, that's how a lot of, I think, the fact patterns come up. Businesses, when they're aligned, work well together, but they're separate entities with separate agendas. And when they're no longer aligned, you can get into disagreements about who created what and what was built on top of whose innovation.
So I'm definitely seeing that in the trade secrets claims that I'm seeing. I'm seeing collaboration agreements or confidentiality agreements that are alleged to be breached, and the research relationship ends, or maybe the research relationship never begins, but then one of the parties is found doing some work that appears to be benefiting from the knowledge of the collaboration or the knowledge that was exchanged under a CDA. And under those terms, then trade secret misappropriation claim would be appropriate, both under trade secret law and under breach of contract.
Right, and in most cases, those claims go hand in hand because the cause of action is actually, comes to fruition based, in most cases, on a breach of contract. Because once you disclose your confidential information to a third party in a business relationship, you've let the cat out of the bag, and the only thing that limits what that third party can do with it is the contract that you have in place that puts limits on how the information may be used and to whom it may be disclosed. So fundamentally, whenever you see collaboration agreement type trade secret misappropriation case, the facts of the case often turn on not just your trade secret claim, but on the contract itself. And I know you have a good example of that.
Right, so the contract, the language of the contract makes a lot of difference, right? Because, for instance, often what happens is one of the companies has come up with a derivative compound that looks a lot like something that was made in the collaboration. And in that case, if that derivative compound is targeting the same target protein or kinase or whatever, then what did your contract say about what a collaboration compound is, and what kind of limits did it put on derivatives? And if derivatives aren't captured by the definition of your collaboration compound, then is it captured in some other way? That is, was there know-how that belonged to the collaboration that should not have been used for individual purposes? And what I see is that patents and patent rights following a collaboration are often very carefully thought through, the know-how less so. So those are important provisions to look at in a contract.
And I just to add on to that, I think that's an important point that you make, Michelle, which is that in the biotech field, in the collaboration agreements, not only are you seeing sort of the use and disclosure provisions for trade secret, but IP ownership and how you're going to define IP rights, including patent rights, is often something that you do see in these agreements, and it's usually very complicated in how the provisions are drafted, and even provisions about how disputes will be addressed, particularly in a post-AIA world where you don't want your dirty laundry aired in public because you don't want to kill the golden goose. You want to figure it out and not in a public setting. So you're not actually injuring whatever patent rights may come out of it. There may be patent rights, trade secret rights, know-how rights, all tied up in the same collaboration gone awry.
The other thing I see a lot is that the scientists who are involved in the collaboration often have never seen the confidentiality agreement or what the obligations are. So they're disclosing, so it's easy enough if you're sending over a slide presentation to put confidential on the bottom of that, but what we see is that there are oral presentations or visual presentations, and usually the contract has some provision that says if information is conveyed in an oral or visual way, within 30 days or within some period of time, you'll send over a written confirmation of what that information was so that you can identify it as confidential. Well, scientists don't always do that, and that can create some ambiguity.
Or you had a really nice example about how confidential information is even defined.
So there are a lot of confidentiality provisions I see that are just cribbed from agreement to agreement. In some cases, there's a clause that says that confidential information is defined as being information that's kept confidential and so forth, but once the information is subsequently made public, then it's no longer confidential information under the definition of confidential information in the contract. So that would suggest that at least under the contract, information that had been considered secret then loses that obligation altogether and that status altogether. So interesting to note what the implications of that would be for trade secret claims, separate from the breach of contract claims.
Well, and if I could just, there was, and just to show how much the contract matters, there was a case that was recently decided, I think it was Well-Logics versus Accenture, where the defendant contended that what was asserted as trade secret had actually been publicly disclosed and wasn't confidential information, even though they acknowledged that they'd accessed the information from a private confidential portal. And in that case, the disposition really turned on who bore the burden of proof to show whether or not it was confidential information or not. And because of how the confidential information provision in the contract was drafted, confidential information was defined, and then there were subsequent exceptions. In these circumstances, the defendant bore the burden and failed to show that at the time they accessed the information, it was in fact public or part of the public patent filing, for example, so they lost that case. You can imagine in Michelle's example, it would have maybe come out the other way because of how the provision itself was defined. What was confidential information ceased to be confidential information upon disclosure. So it just goes to your point, you need a good lawyer.
Yeah, I also wanted to mention one employee mobility case, which is a case BMS versus Berman in Delaware, which is a case where BMS had a scientist employee who worked on a couple of products in their product line, in the immuno-oncology product line, and he quit and went to MedImmune, and BMS tried to enjoin him from working in the broad field of immuno-oncology. The contract had said that he wouldn't work on competitive products or products that he had worked on for the past year, and his definition of competitive products were products that worked with the same mechanism of action as the product that he was working on, and there's very little in the way of logic in the order, but BMS was able to obtain a TRO that precluded him from working in the full scope of immuno-oncology, and that case later settled, so we didn't get more facts out of that, but that's a pretty severe penalty, and we agreed in talking about this in advance that probably never would have happened in a California court, so it again calls into question what happens under the new federal statute if that is pressed. So, so I think we can move on to regulatory exclusivities.
Let me just hop on one
Yeah.
quick thing about patents versus trade secrets. So obviously, we're not the only area of law in town, and many of you are probably already bumping into the patent box. So the patent box presents a reduced rate of taxation on income derived from patented inventions, and it's very common in Europe. However, the definition of qualifying intellectual property varies by jurisdictions, and in some jurisdictions it does include trade secrets. Others it's just patents. So we can all, wail and gnash our teeth about whether it'd be better to have a patent or a trade secret in a particular situation. But when your tax people come to you and say, we can get a 25% tax discount if we patent it, there's probably going to be a bit of push that way. The United States Congress is currently considering having a patent box as part of our tax laws. So just something to be mindful of.
So do you want to go ahead and give us your presentation on regulatory exclusivities and your view?
Okay, so this is
from other panelists.
This is a bit more of a scholarly take for just a few minutes. I'm sorry to, if you'll indulge me, it won't take me too long. And Becky and I are usually fairly familiar sparring partners on this in a gentle way. And let's just to talk a little bit more about regulatory exclusivities and its role in our innovation environment. So we've got three sorts of patents in 1790. About every century we come up with a new one, and it's been fairly stable form of right. Since 1982, we've had 15 different regulatory exclusivities. They vary considerably in length. When they start and when they end varies a lot. What sort of exclusivity you get varies, specifically one among the other. Some are additive, some run in parallel. The bottom line, it's a dog's breakfast of assorted and sundry rights that sort of pop up in all sorts of legislation and kind of unexpectedly. Now, as Becky had mentioned, it's a lot easier, and as through her writings as stated very eloquently, it's a lot easier for Congress to manipulate pharmaceutical innovation or biologics innovation through food and drug law than through the patent laws. It's amazing how quickly this trade secret legislation got through Congress. But of course, we know how long the AIA has been going on, and also the new post-AIA legislation. Obviously, it's very contentious, and that's because it's a big tent, right? It covers all sorts of innovative industries with diverse perspectives on the patent system. But that's not true as much in very specific industries. So when I work part-time on the Hill, and when I go talk to members of Congress or other staff, their issues are really confined to high-tech industries. Their view of the patent system is one that is dominated by trolls, by portfolio litigation. They're worried about FRAND commitments and how those can travel with patents. They're worried about aggregation and the fact that entities are buying up staggering percentages of the numbers of issued patents. And in 20 years, will we have 6 entities owning 20% of all issued U.S. patents? They're concerned about it because that's the future. That's not a future that's that relevant to the biologics industry. It's really a very separate entity, and so everything that's going on with the current post-AI legislation has very little to do with this industry. In fact, there's often very specific carve-outs in the proposed legislation for Hatch-Waxman and also BPCIA, Public Health Service Act litigation. So it gets to be a very sort of incongruous set of circumstances. As Becky's also said, under the TRIPS agreement, the notion is we're supposed to treat all patents the same, regardless of the field of technology. That seems to prevent discriminating in favor of pharmaceutical or biologics patents as well as against them. So the notion is, well, if we can do something in food and drug policy that we can't do through the patent system, and it's much more convenient in terms of our international obligations. What are regulatory exclusivities? Sometimes they're called quasi-patents, and with short terms, there's sort of a short period of protection followed by a period where the patent litigation begins. It's an odd blended architecture that Congress has established because this industry stays somewhat within the patent system, but it's also got a foot out of it. When the U.S. Supreme Court issues a case saying, well, it's very important not to grant exclusive rights and take things out of the public domain that would have been obvious. Well, that's terrific, and that's true at the Patent Office, but if you leave the Carlisle sections of Alexandria, Virginia, and drive around the D.C. Beltway up to Rockville, well, voila, there is a regulatory agency that will hand out rights on that very thing. When you read Supreme Court opinions saying, well, it's very important not to have patents on laws of nature, protection on this sort of thing is bad for the innovation environment, and it's not what we want to have excluded by one. Well, again, that's great, but the Food and Drug Administration will grant even more robust rights on precisely the same invention. So it gets to be a little hollow to read some of these decisions when in fact commensurate protections available elsewhere. Who enforces regulatory exclusivities? As you know, it's the government. You may not even know that your right is being enforced, right? And of course, that's one thing that property owners have the ability to do. They don't have to sue or enforce their patents against everyone, right? They have discretion. Regulatory exclusivities can be waived or transferred, but that's not something that's so commonly done. Patents provide the right to exclude, but again, Mark's famous line is they provide really the right to try to exclude, because it doesn't always work. But regulatory exclusivities essentially are incontestable. They're invulnerable to challenge. The FDA will handle citizen petitions saying, well, you've approved the active moiety of this drug before, so there's no 5-year new chemical entity exclusivity available. Those things happen infrequently. But there's really no way to get these things before the courts. I think what we've seen in the past is the dialogue in front of our court system is really what animates change and allows our society to adapt its patent system to perceived needs of today. The FDA, NIH have had no stomach for spending any time talking about intellectual property at all. They just implemented what the 2003 Medicare Modernization Act just got rigged up. Right, we just had them, and these entities don't really like dealing with intellectual property. It's something. So if we don't have it before the courts, how exactly do we sort of have a public airing of some of the importance of this new intellectual property right? I'll skip some of the other points in the interest of time, but I was sort of asked to talk a little bit about sort of what's the future. If you wanted to bet on a new form of intellectual property and how it's going to go, this would be a great bet because there's all sorts of legislative proposals floating around, and there are very little constraints on the ability of Congress to enact regulatory exclusivities based either on public interest or upon our international obligations. Okay, so still floating around is this concept of wild card exclusivity. So if Congress does something you like, it will give you an exclusivity that you can apply to another one of your products or even sell it on the market. So you can sell 6 months of exclusivity for your blockbuster drug if you do something that isn't popular to do, like, for example, come up with anti-terrorism countermeasures or things like that. You could have exclusivities for just about any sort of accomplishment, right? It doesn't have to be innovation. I mean, it could be anything. Ethnic and personalized medicines are sort of topics of active discussion. Of course, there's a lot of disease groups that lobby Congress and want to have more innovation incentives for their particular ailment. Why not have a regulatory exclusivity? It's fairly easy to pass. Again, anything, domestic manufacture, donations to the poor, any of that, you could have a regulatory exclusivity in theory, right? There's no reason why you couldn't do it. And of course, the other thing floating around is the Modern Cures Act. I'm not sure it actually put in an appearance in the 114th Congress, but that would allow you to swap all of your patents for a 15-year regulatory exclusivity for an unmet medical need. Okay, so that would really, in a sense, move this industry out of the patent system altogether in favor of FDA-regulated innovation. Okay, so I kept it as short as I could, and I welcome other observations.
Well, I'm
Thank
curious what Becky thinks about these regulatory exclusivities run amok.
Yeah, I mean, the only one that I sort of recognize in your description is the Orphan Drug Act. That is, that the Orphan Drug Act looks like a promise of exclusivity rewarded in exchange for doing a certain kind of innovation, and that's it. The others are all about timing the use of an abbreviated approval pathway. If Congress can create the abbreviated approval pathway, it can time when it becomes available. And so it's introducing a new break and setting constraints on when that break becomes available rather than creating something that looks like a new patent created out of whole cloth where previously there was free competition, right? Instead, on the occasion of making it easier for competitors to enter the market, they are setting some limits on when that new ease will become available. Am I missing something?
Well, I certainly respect your opinion, Becky, very much. To me, it's something of, first, Congress, when it passes new regulatory exclusivities, isn't easing anything. It's never reduced the term of any exclusivity. It simply adds to additional exclusivities, right?
Well, that's not the right way to
So-
look at it. There,
Oh, it is from my perspective.
well,
but
I don't know.
I'd like to-
Let's start with the Hatch-Waxman Act. They were reducing a regulatory entry barrier that had previously operated as an absolute constraint, pretty much, on generic entry, right? And then they're saying, well, we want to facilitate generic entry. So we are going to facilitate generic entry, but not immediately, only after certain periods of time have elapsed. So, you could say they're creating this new springing 5-year quasi-patent, but that would be a kind of a misreading of the history. What they're doing is they're saying, previously we've had, in effect, eternal patents forever on everything. We're going to pare that back, but not all of it all at once.
Okay, what the history shows is that prior to the Hatch-Waxman Act, the FDA often used a formulary system or formulation system. So it would allow firms to sort of comply with certain specifications, and that would allow them to obtain approval. So that was done principally for vaccines, but it was done for
Right.
other sorts
Very
of drugs
few.
prior to Hatch-Waxman. So I don't see that that's the terrible swift sword. All of a sudden, it was never done before, and now it can. That's not really what the history
I'm
demonstrates.
overstating it slightly, but only slightly.
So let me bring this back to the practice. And Deborah, can you talk to us about how these exclusivities interact with patents?
Sure. May I borrow this
I'm so
the
sorry,
slide
pardon.
sorter? No problem. And I will go over this fairly briefly because we've already covered the different available exclusivities. But I thought a visual might be helpful because, and it's complicated. It depends on the facts of a given case. But I thought it might be useful to see how these different exclusivities interact both for a small molecule product as well as for a biologic product. So I'm just going to put up some graphics. And what you can see here, and these are completely arbitrary dates, but that in the generic space for this particular hypothetical compound, if you were to stack up, for example, your orphan drug exclusivities on different indications, I haven't done it here, but you could imagine it would run out beyond your compound patent, for example. So you can have fact patterns where for your particular drug, the marketing exclusivities or the regulatory exclusivities end up having substantial meat to it. Now this all assumes that you have patents to start with, and as Becky mentioned, even if you don't have a patent, you get at least a minimal amount of NCE exclusivity. But you can really layer, and so that's what this is sort of showing, is that you can add on to your base patent protections with additional layers of regulatory exclusivity. And then what's interesting, and I think most people probably know this, but the additional 6 months of pediatric exclusivity for small molecule compounds can both extend each of your regulatory endpoints, but also add 6 months of additional exclusivity to all of your Orange Book listed patents.
Can I ask a question about the chart? Is the orphan drug, is that exclusivity supposed to start at the same time as the NCE, or is it, I see you have a delay?
It's not, it doesn't. It starts for when, that's a good question. It depends on what the orphan drug is for, but typically what will happen with your orphan drug is it's for a particular method of use or particular method of treatment. Mm-hmm. So you may get approval on a compound where the original indication that you go for on your label is not an orphan use. But if you later
Okay, so that's your
file
hypo.
on, yeah, that's
There's
right.
there's an additional indication.
Yes,
Okay.
and in fact, what you see it's not uncommon, particularly in sort of the ultra-rare, ultra-orphan type products, is that you have a number of different orphan exclusivities that get approved much, much later, much beyond. And so your orphan drug exclusivities can run out quite a bit.
But they only exclude that indication for
yeah,
approval.
for that particular indication. And then the other thing about orphan drug, is it's only for that particular effective compound or that effective ingredient. So it's, I don't know how many people in the room are following sort of the Sarepta BioMarin. Now, unfortunately, it doesn't look like either product is coming to market based on just what I see on Fierce Bio. But there's an example where you have two companies developing products for the same disease state, which is Duchenne's muscular dystrophy, but the active ingredient was a different sized, basically different sized sequence, different length sequence. So they were both eligible to receive orphan drug exclusivity. But neither one's orphan drug exclusivity would prevent the other one from entering the market because they're different effective ingredients, but it may prevent a copycat. And that's true for all of these regulatory exclusivities, is that it's premised, as Becky said, on the quid pro quo for allowing somebody else to rely on your data package. So unless somebody's doing exactly what you did, the regulatory exclusivities are not very effective. If somebody wants to come on the market with a differentiated product, then you do rely on your patents to give you more coverage than just the regulatory exclusivities. But here's sort of an interesting point on the biologics. So again, arbitrary fact pattern that I picked. And here, one of the things that's, well, let me go back. So one of the things that you see is that what we call the earliest you can file for a generic on the NCE exclusivity is 4 years, and the maximum you get on your NCE exclusivity standing alone is 5 years. On the biologics now with the BPCIA, you get 12 years of market exclusivity and only 4 years of data exclusivity. So theoretically, somebody could file an ABLA at 4 years, but strategically that might not make a ton of sense. But here, with the biologics, again, you have the additive effect of the orphan drug exclusivities, et cetera. However, because there's no Orange Book listing, the pediatric exclusivities do not attach to your patents. So again, they interplay, they layer, depends a lot on the facts, depends a lot on the kinds of methods of treatment that are available for your product, whether you can continue to layer on regulatory exclusivities. But in the interest of time, I will say there are other interesting...
We actually have plenty of time, so...
Oh, we
keep
do?
going.
Okay. Okay, great. So, but yeah, so maybe this would be a good time to mention. So one of the... strategically, one of the things that that new entrants are looking at, particularly in the biosimilar space, is where you have a regulatory exclusivity that goes out 12 years. If your base compound patent is similar in length, let's say, the incentives to challenge the patent may not be as robust as in the ANDA space, where typically your regulatory exclusivities are very short and your patent protection, even on your base patent, takes you out much further than the 4 or 5 year exclusivity, depending on when it's challenged. So here, it's a different regime, and we've yet to see how people will strategize around it. Most of the products that we're seeing filings on, where people are submitting, are sort of the blockbuster biologic products that have lost their marketing exclusivity long, long ago. And what we haven't seen is for newly approved biologics, where the marketing exclusivity, has a decade to run, and maybe the patent protection has 11 or 12 years to run, and the barriers to entry in terms of developing the manufacturing ability to even enter as an ABLA applicant are pretty high. What will be the incentives to challenge the patent versus to wait it out and come on the market? So we have yet to see all of that. But in the context of this talk, what you can see is that the regulatory exclusivities for the biologics in particular are pretty attractive, and even for the NDA holders, by using various regulatory exclusivities in conjunction with your patent protection, you can provide yourself with more coverage in the event that your patents are under attack via all of the different challenges that we're now seeing in the biopharma space.
So I agree with your commentary on the 12-year exclusivity period and how that will interact with patents on new drugs that still have the 12 years of exclusivity. What is interesting, though, is that even for those drugs where the 12 years have passed, there are still lots of patents out there in the usually methods of treatment or different formulations, new methods of treatment that seem to be living far past the 12-year exclusivity period for the drugs that are being challenged.
I think that's true, but this again is how the pendulum swing has affected us all, which is I don't know that anyone anticipated when the biosimilars legislation was passed how IPR, or the new post-grant challenges, would play into the mix. Mm-hmm. And at least what we're seeing is for products that have, their marketing exclusivity has long expired, and we know that there have been ABLAs filed on the products, that the first line attack against the innovators' patents appears to be happening in the patent office in the form of IPRs, where you don't need standing, you don't need to be near approval to take your pot shot. And now there's law out of the Federal Circuit saying that if your challenge isn't instituted, you're not stopped. You can bring your challenge again. So you can always bring it a second time. And multiple biosimilars can bring a challenge against the same patent. And from all of the statistics and research I've seen, and it's not surprising, the one constant is the more times a patent is under attack, the more likely it will be found to be invalid.
Well, one interesting thing, and this topic, the panel isn't intended to cover IPRs, but at our firm, we've been tracking life sciences IPRs and looking at their success rate for institution, and they're not as high as other technologies, and there could be various reasons for that. And so the reliability of knocking out a patent through IPRs, at least so far, and the numbers are still low because life sciences patents came to the IPR process late, but so far it's not as a strong tool as it has been in other industries in our assessment.
Just to follow on that, that's true, the statistic of institution is lower, but the cancellation rate is higher once instituted.
Once instituted.
Once instituted, more claims are canceled. And I think it was a shock to us, at least, when in the Kyle Bass. So for those who aren't aware, there's this fellow Kyle Bass who had a company called the Coalition for Affordable Drugs, and he claimed to be taking pot shots at pharmaceutical patents in order to lower drug prices. While I don't think that's happened, there was a suspicion that he was really just manipulating stock price. And of his initial 30-plus IPR challenges that he filed, very few were instituted. However, for the ones that weren't instituted, he filed subsequent challenges, and a number of those have been instituted, which is interesting because it means that the Patent Trials Appeals Board, again, these post-grant challenges, you can file seriatim attacks, and there's no bar to that. And particularly in, one of the things that's interesting for biologics is maybe not all of the patents are as known as in an Orange Book listing environment for small molecule. Once the main patents are known, you have a very long period of exclusivity in which to take pot shots at the patent through IPR, and multiple players can take those challenges to the Patent Trials Appeals Board. So I don't know that that was what was intended by the AIA, but we're still dealing with the fallout.
So Becky or Jay, do you think that these exclusivities provide too much protection?
That's really difficult to say. I think that particularly the biologics exclusivity provides more protection than any other regime anywhere in the world, and is something that we're getting pushback in treaty negotiations with our agreement, the trade agreement negotiations with treaty partners. I think they managed by attaching this to the Affordable Care Act to get more robust protection than probably would have been available otherwise if this had been a freestanding piece of legislation. On the other hand, the downside is it was draft legislation that was rushed into law, and therefore has a lot of ill-considered provisions that are proving problematic and generating considerable confusion. But it seems to me that 12 years is a healthy amount of regulatory exclusivity. Your last comment, Deborah, was presenting this as if, look, there's this really extended period of time in which we're vulnerable to these PTAB proceedings, but of course that's the price of getting a really long period of exclusivity. It's really hard to say. That's an empirical question, I think, that's a moving target, how much exclusivity is enough. I like it that it is so divorced from patents. I think that seems to me like a good thing that creates more certainty for everybody, less wasteful litigation. And so, whatever the right period is, it seems like it would be better if that is running independently of patents.
Okay, well, I think I've sort of answered that already. One person's trash is another's treasure. Wasteful litigation also puts intellectual property issues before the courts and allows us to have a dialogue and shape what our innovation environment is going to be. And so when you have something that's automatically enforced by agencies that don't like intellectual property, and are indifferent to it. It seems to me, I don't know if it's too much protection. I agree with that's an empirical question, but it's not a healthy atmosphere for us to consider these issues.
So sitting in Washington, D.C., what do you see as the future of exclusivities?
Well, I think, as I said, I think the future of exclusivities is fabulously bright because Congress can easily augment any of the exclusivities for any sort of minor disease group or really for any task that it wished to have accomplished. Since we're on that, and maybe we can circle back to regulatory exclusivities. Maybe I could just mention a couple other pieces of legislation I think are going to be impactful, and I'm sure most of you in the room already know about them. So one is in the pre-legislative mode, or there's some drafts floating around. And those are the ones dealing with the Bayh-Dole Act. So Deborah mentioned earlier in her talk, and of course we had our luncheon speaker talking about her delightful interchanges with patent lawyers and all of that. And all of that's made possible by a statute I'm sure virtually everyone in this room knows well. It's the Bayh-Dole Act. So Bayh and Dole were the name of the legislators. And in short, what this allows government contractors to do is retain patents in their inventions. So it's a fairly short statute. But again, if there's government projects, NIH, for example, NIH funding, which you mentioned as a source of pipeline for many biologics firms, that the university ultimately can obtain the patent. Now, the government gets a paid-up license, but it also has something called march-in rights. So if it wants others to use the patented invention, it is allowed to march in and license another. And so this is part of the package deal that Bayh-Dole includes. March-in rights have never been exercised in the 35-year history of the statute. As far as I know, there have been 6 petitions before the NIH, and every single one has been rejected. The most recent one involved, I guess, a fairly rare disease in which those suffering from it claimed drug shortages. And even then, the NIH was unwilling to grant the march-in. One thing U.S. Congress is always going to be interested in is drug prices. Okay, obviously through Medicare, Medicaid, Veterans Administration, the drug prices are always very much on the mind of Congress. And it has come again. It was popular about a decade back. The notion of using expanded march-in rights to control drug prices is very much on the agenda right now. So the extent that you're relying on patents that have an NIH funding and have a Bayh-Dole statement, then they become a little bit more susceptible to march-in rights should this act. It's early days. There seems to be a lot of traction. I just don't know what Congress is going to do. I think an NIH hearing on this is going to be coming up soon, and that would be my next guess about sort of the next steps. Right now, the NIH doesn't even have any regulations on march-in rights, right? It regulates from the statute and isn't doing too much. So I think that's something sort of on the horizon. And another big topic that's coming back is parallel importation, so-called re-importation. So this would allow you to buy drugs abroad or allow third parties to buy biologics abroad and then bring them into the United States. There were a lot of bills on the table, but they got swept off during the Obamacare era. Now they're back. So they would allow basically re-importation or parallel importation of drugs, some from just Canada, others name a large number of countries. With that much motion, there's probably going to be something going on. What's interesting about the bills is that none of them actually speak to the intellectual property implications of parallel importation. Okay, so predecessor bills from the 108th Congress actually exempted you from patent infringement if you brought in biologics, so long as you bought from the original patent proprietor. Now, obviously, that's the Lexmark issue, right? The Kurtzsang case, the copyright case, which allows for international exhaustion of copyright. Did the Federal Circuit read that correctly in Lexmark when it decided, no, that's a copyright case and patents are different? So we'll see what happens if Lexmark or a similar case gets before the Supreme Court, or if Congress decides to intervene itself. Under the TRIPS agreement, there doesn't seem to be any problem with having a pharmaceutical or biologic-specific international exhaustion rule. So that's something that you might see in the future. Curious, any observations on that or anything else?
Did you want to add something, Deborah?
Well, I was going to pick up on Becky's last comment, but if anybody wanted to speak to Jay's, that's, well, so on the 12-year ABLA exclusivity, I do think it's important to keep in mind that these various regulatory exclusivities we're talking about all presuppose that an applicant's going to want to file on an abbreviated pathway based on the reference product sponsors data package, right? So just to sort of reset the table a little bit, until a couple years ago, there wasn't an abbreviated pathway, and yet there was still biologic competition in the market. You had multiple innovators filing for separate BLAs, and you would have patent infringement litigation, whether those products were the same product or differentiated products. And I think that the calculus for newly approved products, newly approved biologics, where the marketing exclusivity is going to go out 12 years, I don't think it's off the table that even if it's a very similar compound, or if a competitor's thinking about entering the field or taking a flyer, that they would necessarily wait and file as an ABLA applicant. And certainly in a case where you have a differentiated product, you have, you know, a protein where you've got one amino acid difference, or you've got, you know, somehow a slightly modified antibody. You know, these regulatory exclusivities only apply if it's a Me Too product. So I guess I view them as complementary. I don't view them as handoffs. So when you say that you get your 12 years, it's not, it protects you against a set of competitors, but it's not as binary as the ANDA space, where you really don't see two branded small molecule companies deciding to invest in bringing to market the same small molecule product at the same time.
But isn't that just a reason why the innovators are even better off under the biologics legislation than they are under the Hatch-Waxman Act? That is, not only do they get 12 years, but the regulatory break actually isn't that great. So most people aren't going to bother with it. And if they're going to bring a product to market, it's going to be through their own full-blown biologics license application rather than through an ABLA.
Or they might, right?
Yeah,
They
so
might.
it seems like that's not a reason why the 12 years is inadequate. That's another goodie for the innovators.
Oh, right. I don't know that the 12 years is inadequate. I just, the point is more that you're not guaranteed that the 12 years is going to keep competition off the market for 12 years.
Right, and nor are you in the small molecule space, right?
Correct.
You could have somebody else bringing the same product to market with their own NDA. You don't see that, but
It's true, but given the length, I mean, so this is where, you know, this is where actually calculus would come in handy to find the area under the curve. But I think that because the exclusivities are so much shorter in the small molecule space, there's less incentive to qualify up on your own.
But it's
Right.
also true that biosimilars are here to stay. There are companies that
Yes.
are taking it on and finding that not having to do those extra clinical trials is a business model. And so while there is still the opportunity to file your own BLA, the biosimilars are coming, and they're here. So
That's definitely true.
so those are all of my questions, and thank you, panelists, for coming and for a lively discussion. Does anyone have any questions? Could you come to a microphone?
Yeah, hi, I'm David Larson from McDermott, Will & Emery. I have a question about the new federal trade secret legislation. California has long had a provision that's not really part of its Uniform Trade Secret Act, but it's in the Code of Civil Procedure, which requires a plaintiff to put its cards on the table even before they can take any discovery. And that has acted as a certain amount of, had a certain deterrent effect, I think, on trade secret cases. And that's been adopted by the federal bench as well in California. So I guess my question is, because I haven't read the new act, is there any provision at all that gets into that sort of procedural side of things? Or is it likely that someone bringing a trade secret case under only federal law and not invoking state law could avoid having to disclose their own trade secrets to the opposing party before they can take discovery?
Well, the capable practitioners on this panel alerted me to the issue. I'm happy to say, so I thank you, and it was obviously a good issue for them to inform me about. So I looked it up and went through the legislative history. The bottom line is there is no such identification requirement in the federal law. So this is an issue that just is not mentioned or discussed, and that might be an advantage for a litigator who's looking to forum shop.
Jay, the one exception to that, I guess generally right, the one exception is that they do require specific identification of trade secrets before you do the ex parte seizure.
Right.
Yeah, that's true, okay. I stand corrected on that one, you're right. For the ex parte one, you're right. You're right, yeah, Mark's right. For the ex parte procedure, you would have to do that, but for a general claim of trade secret misappropriation, there's no specific requirement. That's correct.
So we have time for another question?
Yes.
So one thing that has bothered me a little bit about the debate over, well, that took place before the BPCIA and then subsequently arguments have been made along these lines is that somehow patents could be avoided through one amino acid change in the biosimilar, and yet you could still rely upon the same data as the originator. I don't think the FDA would allow you to get away with a one amino acid change, given how strict they want you to be relative to the biosimilar. And patents generally, you know, even despite written description, they're pretty broad, and at least as I've seen them in the biotech space. And I don't see a situation, in fact, I would be surprised if I ever saw a situation where you got to rely upon the originator biologic data but somehow could evade the patents, which was a big argument for why there was 12 years was needed. And that's just bugged me for, you know, it's more a comment than a question, I suppose, but I think that's sort of a red herring.
Artie, the bio industry is a master of the committee system in Congress, as you know. And they will go to Senate Judiciary and say, our patents are incredibly important. We have to have the patents. Get us out of IPRs entirely. We don't want anything to do with this new AIA legislation. But then they will go to HELP and other committees dealing with the Public Health Service Act and say, our patents are terrible, they're useless to us, and we need a 12-year exclusivity.
So
it's
I
part of
was
that.
contacted by people on Henry Waxman's staff about this way back when, before the BPCIA passed, and it always struck me as an odd argument, and I still haven't seen an example of it. So,
I just want to make sure that my comment wasn't misinterpreted. So when I was talking about how, you know, making a decision about filing as an ABLA applicant or as a separate BLA applicant, my point was that unless you're going to file a Me Too product, so for example, let's say you had a 20 amino acid sequence patent and somebody could choose to piggyback on your 20 amino acid sequence and file an ABLA, or they could come up with a differentiated product that was 30 amino acids in length, not file as an ABLA, file as a separate BLA holder. None of your regulatory exclusivities would prevent them from getting approval or entering the market, but if you have a patent on your 20 amino acid sequence, it would, presumably, if it's the same sequence plus 10, cover their product. So the point was that the regulatory exclusivities work like patents for the same products, for follow-on products.
I understand.
Yeah, yeah.
Oh,
okay.
I wasn't suggesting you were.
Okay.
I was just thinking about this point that I've heard many times before, and just wanted to get it out.
Okay, okay.
You weren't making that.
Okay.
And my interpretation of what you said was that if you had a single amino acid difference, then that shouldn't be any basis for being outside the regulatory exclusivity. Is that right? So even if you have a single amino acid difference, if you have a 20 amino acid difference, if you're going to rely on the data of the originator, then that would trigger the exclusivity, I would think. Yeah.
That's correct, but I don't think the FDA would allow you to go in with an ABLA that was that different.
Right.
Well, that's a different question, whether you could prove that it was biosimilar.
What the biotech industry said to Congress was that there might be a situation where somebody would be able to evade the patents and go in with a biosimilar application that evaded the patents that relied upon the data of the originator. And that's why the 12-year exclusivity was needed on top of patents. Patents are useless.
I think at
the time that this debate was happening, there were no ABLAs yet, and it wasn't clear how different something could be and still qualify as biosimilar, so that they were making kind of both of these arguments at the same time.
Yeah, although I think it was pretty clear that given the history of where the FDA, how reluctant the FDA has been to even engage in this pathway, that it wasn't going to allow huge amino acid variations. And frankly, the patents, even with written description and all that, do allow some variation in even an amino acid sequence in terms of the genus that they cover. So anyway, that's just, sorry, it's orthogonal to what you guys were talking about, but it occurred to me that this was something that really bothered me, so.
We have a question over here. Do you want to do?
So my question, I was listening a lot to this, and it reminded me, first of all, of something was said here by Johnson & Johnson patent attorney. The first one of these I attended maybe 8 years ago or so.
Could you get a little closer to the mic, please?
And this J&J attorney said that we pick the drug to go into clinical trials with that is the most effective drug to which we can get adequate patent protection, not the most effective drug. Mm-hmm. And there are very few incentives for a pharmaceutical company to do the economic investment for the most effective drug if those two don't closely overlap. Since that time, we've had the rise of personalized medicine, and we have many folks who have spoken in many of these meetings who talk about how to rescue your investment in clinical trials, you have to limit your patient population, genetic testing, companion diagnostics. All of these things are important to the public policy related to the health of the populace, but they are antagonistic to the current protection regime. It seems to me that data exclusivity or some other protections like that might encourage companies to develop in an orphan drug-like thing these personalized approaches. And I'd like for someone to address what are the incentives and what are the counter-incentives that these various regimes do to promote the right drug for the right population. Thank you.
Well, that's certainly what it's all about. I'll just say quickly that pharmaceutical and biologics firms aren't alone in developing products for which they can obtain robust intellectual property rights. It's not as if other firms and other industry sectors say, as between these three products, I'm going to take the one that's already been patented by my competitor and start selling that one. Okay, everyone does intellectual property inventories. Now, it may be that the case for life sciences and pharma is more compelling. Okay, so I'll accept that part. Okay, but certainly drug companies are not the only ones who look at the intellectual property landscape before choosing to develop products.
Well, and like everyone else, these are companies with shareholders trying to maximize profits. So I think the trick is, how do you create regulatory incentives that make people do the right thing? And some of the regulatory incentives that I think are out there, I think expedited review for drugs where there's truly a long felt need or there's really no adequate treatment. I think that is going to go a long way to having firms take risks in developing new treatments as opposed to just incremental extensions of existing products. I think earlier Becky had mentioned for infectious diseases, certain additional exclusivities that are very attractive that maybe incentivize people to go and test for drugs that often are in markets that aren't just the US. But you can get extended US exclusivity for going into infectious disease areas. Pediatrics that Becky mentioned also, you don't even have to succeed in your clinical trials for pediatrics. It's just that the government is trying to incentivize people to do medical testing in children because who wants to do medical testing in children? Mm-hmm. So, right? So I think that this is the tension in a capitalist society. People align to maximize profits of their companies, and the trick in government, the trick for the regulators is to figure out how do they offer incentives for people to align their profit motive with doing the right thing for social need.
I would say, though, in comment to Jay's point, I think in pharma, the IP, and we've talked about this, other panels have talked about this, is a much bigger driver on decisions than it is in many others, where you have IP, you have manufacturing efficiencies, and you have all these other things which you can use to compete, even if your IP position is not as strong. And in pharma, you're dead, unless regulatory incentives give you a chance.
Well, if I could just make one more point, and I know we've got other questions, but the other thing that's unique about pharma and really any regulated industry is that at the moment in time your product is approved, really from the time of filing, your product is set in stone. I mean, you can have improvements and enhancements to it, but your IP is more valuable in this space because it actually covers the product you're marketing in many cases, unlike in the high-tech industry where by the time you've got your patent, you're on your third generation product. And I know that there have been, academic discussions about having different kinds of patents in different kinds of fields, but in biopharma, a 20-year patent actually is going to cover your product that's in the market for 20 years, which I think is unlike most other industries.
There was another interesting aspect to your question, which was about these niche products and the development of small products for smaller markets that are, and I think that's a very interesting development that we're seeing, sort of the rise of the orphans, that a really large share of newly approved products now are, 10 years ago, everybody was looking for the blockbusters. Now they're looking for the orphans, and I think that's only partly about regulatory exclusivity. I think a big part of that, and we were talking about this earlier, is reimbursement, that you're able to charge more and fly under the radar of the cost containment strategies of the payers and make a lot of money. So I think we're seeing the rise of the wealthy orphans, and I would not have predicted that. That's quite interesting.
There's a short comment and a distinction as to orphan products in Europe. You were saying that these exclusivities only protect against Me Too products. In Europe, the orphan exclusivity is not only longer at 10 years, but also it protects against similar products. That assessment of similarity is made by the regulators, and they have a very broad view of what is similarity, much broader than that of a patent lawyer.
That is interesting.
Are there any other questions? Well, thank you all. Congratulations on enduring.